And welcome back to Military Law Talks. So, today we have an update in the Fork in the Road case. So, if you remember, federal employees got an email saying, "Hey, here's a fork in the road." And they were offered a deferred resignation. So, that's one thing that the media keeps getting this wrong. They keep calling it a buyout or um, a severance package. It's not. It's deferred resignation. So federal employees were offered the opportunity to say that they're going to resign, and if they do so, then they would not have to return to the office and their remote work, telework, etc. And they would be encouraged to be placed on administrative leave until their resignation was complete at the end of the fiscal year, September 30th, 2025. So the labor unions filed a lawsuit against OPM, which is the HR for the federal government. And the judge issued a temporary restraining order to maintain status quo. So what OPM did, sent another email. The opt-in period was supposed to end Thursday of last week. They sent an email to all the employees. They extended it till Monday. There was another hearing on Monday. The judge did not issue a ruling until yesterday. So it was extended again from Monday until further notice, until we got heard from the judge. And yesterday, the February 12th, the judge issued his ruling. And last night, another email went out to all federal employees explaining that the fork in the road offer is over. If they did not have a resignation by yesterday, then that was it. That was the deadline. No more ability to have the deferred resignation program. So let's get into the opinion, because I've seen a lot of stuff on social media saying the judge reversed himself, a lot of kind of misreporting, or it's over. Let's see what the opinion says. All right, I'm going to share my screen. All right, so remember, this was Judge O'Toole from the District Court of Massachusetts. Remember, he's the Boston Marathon bomber judge. And what I had found was reports of him seem to be that he's pretty fair, even-keeled, calm, cool, collected. And let's get into his opinion. There's weren't a whole lot of thought out there that he was a partisan hack, and I think he followed the law so let's read his opinion. All right. So again, issued yesterday, February 12th. He explains kind of a little bit of the background, that these labor unions representing federal employees are the ones actually suing. They're the plaintiffs in this case, and then suing over this fork in the road directive. And so it says this directive was for certain federal employees. Remember, some federal employees have been exempted from this. Border Patrol, TSA, I believe, obviously military members, they were exempted from this. But it was an offer for them to resign their position. And then the opinion says that, that they would cease active work in their respective agencies. Now, that's not entirely correct. As I have explained in previous videos, which I will link below if you haven't watched them, OPM recommended to the agencies that these employees be placed on administrative leave. However, some agencies have pushed back on that, particularly the IRS. And I've heard from some sources that not even people who have opted into this have not been placed on administrative leave and have still been required to come into the office and not telework. So not entirely accurate, but still be paid their existing salaries. Because they're still employees. Remember, they're still employees. It's just a deferred resignation. They're still employed. And then in addition, they'd be free to pursue other remunerative employment outside the executive branch. Now, as I've explained in earlier videos, that's not entirely correct. There's still several ethical responsibilities and ethical requirements of federal employees that would prohibit certain types of outside employment. And so any federal employee who opts into this program needs to be very careful about finding other employment to ensure that they're not violating any of these ethical rules. Particularly, there's criminal conflict of interest statutes and representation statutes that they want to be sure that they're not violating. All right. And again, just some background sending the email was sent out that it would expire February 6th, but then the legal action came. This lawsuit was filed February 4th. And as I've explained in earlier videos, we went through the complaint that there were two claims asserted in their Administrative Procedures Act and they asked for a temporary restraining order to stay the directive's closing. Obviously, the defendants, the government, opposed this motion. And so on the 6th, the court ordered the defendants, the government, from enforcing the deadline. And then there was a hearing on February 10th. And this order is a result of that hearing. I did discuss that hearing in an earlier video, which again, I will post below. So in order to get a temporary restraining order or a preliminary injunction, it's the same standard. And they had the temporary restraining order, and now the judge is ruling on this preliminary injunction. These are the 4 elements, which I've explained in a previous video. And the judge is not going to get into them very, very deeply, so I won't either. So the judge states very plainly the plaintiffs are unable to succeed on the merits of their 2 administrative procedures claims. Remember, they're claiming that the emails were arbitrary and capricious, and that would violate the APA because they lack Article 3 standing. And this court does not have subject matter jurisdiction over the claims asserted. So essentially, this judge is kind of punting this case. He's saying these labor unions they are not the right party to bring this lawsuit. They don't have the ability to bring this lawsuit. And this court, the federal district court, also does not have subject matter jurisdiction, which means they can't hear this type of case. And the opinion, and I will explain why. All right. So first, the court says the unions aren't the right people to sue. They shouldn't be the ones that are the plaintiffs in this case. He says standing requires the plaintiffs to be more than mere bystanders and instead requires, quote, a personal stake in the dispute. And he cites another Supreme Court case, a recent Supreme Court case, that the plaintiffs cannot manufacture standing through self-inflicted harms. So the plaintiffs here in this case, the federal unions, said that they essentially they had a case in controversy, right? That's the language from the Constitution that grants the judicial branch the ability to hear cases. It says cases and controversies, and they said, "Hey, we're harmed because we have to provide all these resources and all these take all this time and money to be able to respond and properly counsel their union members." And the courts is saying, nope, that's self-inflicted harm. It's not actual harm. The government's action isn't directed towards the union. You don't actually have a controversy here. So it says the plaintiffs are not directly impacted by the directive. So they just argue that they have these, what the opinion says, upstream effects, and that they have to answer questions. They have potential loss of membership, potential reputational harm. But the court says the unions do not have the required direct stake in the fork directive, but are challenging a policy that affects others, specifically executive branch employees. This is not sufficient. Just as the court found in in a previous case, the plaintiffs cannot establish standing. So, hey, unions, sorry, this judge says you don't have a case. He says it's really should be the individual employees. So individual employees could bring a challenge to this fork in the road email. However, I'm going to caveat, we're going to put a pin in it because the next portion of his opinion explains why the federal district court is not the place for that type of um, complaint. So he says this court lacks subject matter jurisdiction to consider the plaintiff's pleaded claims. He looks to a DC Circuit case. Now, this DC Circuit case from 2019, this is from the previous Trump administration. So previously, in the first Trump administration, Trump issued 3 different executive orders that essentially made it a little more difficult for public sector unions. It changed what things that they could bargain over. It made less things bargainable, which means that management could just make a decision and the labor unions didn't have a say. Um, they also took away official time. So prior to the Trump administration and these EOs, and even after, because Biden rescinded these EOs, labor union members, the union stewards, union presidents can use official time. So they're government employees as well. But when they get elected to the union, they could use official time, meaning taxpayer dollars, their time that they should be doing their job to do union duties. And I've seen some personally in my own career. I've seen some union presidents, union stewards who work entirely. They don't do their job at all. They spend 40 hours a week doing union duties. Um, and so Trump, one of the executive orders in his first administration, which I suspect he'll probably bring back in this new Trump administration, took away that official time and limited the official time. So um, those this court is citing that decision that upheld those executive orders. It took a couple years um, throughout the Trump administration, but they upheld those executive orders. And in that case, they said that the union's claims fell within the federal labor management relations statute, which essentially means this is a statute that Congress passed that set up the ability for public sector labor unions, but said that if they have a dispute, they have to go to the FLRA, the Federal Labor Relations Board. It's FLRB, sorry. And then, but the act is the FLRA. That they have to go to this board. It's an administrative agency. It's quasi-judicial. They have to go to that agency first and have their dispute heard there before they can come to court. So this Judge O'Toole, in this case, is saying same thing here. If unions lack standing, individual employees could bring a complaint, but they're going to have to go through the statutory framework, meaning they have to exhaust their administrative remedies first, which means they're going to have to file a grievance, and they could file an unfair labor practice with the FLRB. So that's where it's at. So essentially, the judge is kicking this case out of his courtroom. And so this is where he explains that this complex statutory scheme, you got to go through, you have to exhaust your administrative agencies, right? Like I said, do a grievance first, and then potentially a board, and then potentially you can go to the FLRB, and then the court here is saying, hey, labor unions, you don't have standing and you're here too soon, essentially. You need to go exhaust your administrative remedies. And so he's citing several cases that explain that support his decision. And so finally, at the end of the day, labor unions lost on this one. Trump administration won. So for the foregoing reasons, the temporary restraining order previously entered is dissolved, right? Because he made his decision. It was just temporary. And the preliminary injunction is denied. So the program, the fork in the road, continued. And as I said earlier, federal employees got that email last night saying, hey, time's up. If you haven't put in your deferred resignation, that's it. Program's over. So I suspect this case will eventually get dismissed completely out of his jurisdiction. Judge O'Toole turned out to be pretty even-handed, not a partisan hack. So I think it's a interesting decision. I think based on the law, correct decision. And so the Trump administration wins this one. And we'll see what happens with the other cases. So we've have lots of pending cases regarding Trump's EOs. We're going to continue to cover that. Tomorrow, I am going to cover the military vaccine mandate. I'm going to give a little history on that. I'm going to explain what happened. And then now the DoD is offering to reinstate service members, but it's kind of limited. And the back pay isn't all that it's cracked up to be. So we're going to go through, we're going to read the fine print, and we're going to explain it. And that's our video for tomorrow. So thanks for joining me tonight, and I'll catch you tomorrow. Have a great evening. Good night.